we're still charging you interest and we're still letting it accrue. But we have not eliminated lines of credit. Now, it really is something that maybe you should check on if you do have a line of credit, because a lot of those lines of credit through institutions, and we are one of them, we haven't done it, but I know it was done back in 2008 and 2009, is they're callable on demand for the institution. So if you have no balance on it and it's something that you think you're going to use, your institution, depending on how they set it up and the language in their document, could close that line of credit on you for no reason at all other than they're trying to minimize their exposure. So that's something to be cognizant of. And they could, and again, you really have to check with your institution, or maybe just look over your loan docs. They could freeze you from using your line of credit any further. We have not done that. We're still using that as a mechanism, as a credit facility for working capital purposes. But it's something to be very aware of. In regards to refinance, I kind of touched upon that before. We're looking at it from a case-by-case instance. If you still have good cash flow and you still have a lot of tenants that are paying, but you might have one or two, but your debt service coverage is still in a position that we feel comfortable with, we still will do a refinance. Now, we might have it under more conservative terms, as I mentioned, but it's something that we still have been considering and will consider. Next question is, I see that Jim asked about COVID escrows. We have not required that yet. We do have some individuals, as I mentioned earlier, that are taking it upon themselves to set up not so much escrows, but more reserves. But there's nothing that we've done or nothing that we've asked for any of our borrowers to set up any type of reserves yet. However, there is a caveat to that as well. On some of our bigger loans, we have been putting a principal and interest reserve as part of the conditions of the loan. So we've been doing, if there is a refi with a little cash out, or if it's an acquisition, we've been setting up P&I reserve accounts to try to make us feel more comfortable with the loan. And we've done some for our larger deals. Just to kind of backtrack, we do deals anywhere from $50,000 all the way up to $35 million. So there's a big difference in the spectrum of what type of deals we do. So those P&I reserves that I'm speaking about have been geared more towards our larger loans to kind of mitigate some of the risk that's involved with these deals. But it's not to say that we wouldn't do it on smaller one. But the short answer to Jim's question is we have not required and we have not set up COVID escrows for any of our commercial mortgages yet, unless you want to consider the P&I reserve as kind of a COVID protection under just a normal moniker of a P&I reserve.
All right, thank you. Thank you, Josh. We have a long program, and people that have more questions, please send them in, and Brian will edit them. I think we should get to the attorneys, and then we can go to Greg. We could start out with Paul Cohen, who's the attorney for Hapco, and then after that, Kenny Barretts, to let us know. I'm sure there's going to be a number of questions for them, so they can update you. Paul, can you join us now? Paul Cohen?
Yeah, 1 second. He's getting unmuted.
Yeah. Thanks, Brian. And thank you, Harvey. And a special thanks to Jared Solomon for speaking tonight and spending time with us. I just want to say that in working with legislators over the many, many years, I won't say how many years that's been, Jared is just awesome. He's somebody that gets it in the sense that it's not just all one-sided. He listens to both sides of all issues. And you get legislators that will listen to both sides, but it's rare that you get a legislator that really listens and hears what we're saying. And Jared Solomon is that person. So it's just been a pleasure to work with Jared on these different bills and just in general on landlord-tenant issues. And just want to thank him personally for that and all the help. I do want to talk about the eviction moratorium and when, if ever, that's going to end. So it's very confusing. I'm going to try and simplify it in the next couple of minutes. I'm not going to spend the hours that I could to go through it all, but I'll just try and give you an overall sense of where we're at and where I think that we're going to be. So there's three different moratoriums. There's the federal moratorium, there's the state moratorium, and there's the city of Philadelphia moratorium. And then all separate from that, you have to figure out what the courts are doing or allowing you to do. So just real quickly on the federal level, you have the CARES Act. If you have a property that's a covered property, the moratorium was in effect until July the 25th. That moratorium is over as of this moment. However, the president is talking about extending it. The House has passed a bill to extend it. The Senate didn't approve it. The Senate's bill does not include an extension of the moratorium. We really don't know where the federal government's going to end up on all this. If I had a crystal ball, or if I was going to guess on where it's going to be, there's going to most likely be some type of an extension on that eviction moratorium. The president is certainly pushing for that. I'm guessing also it will only include covered properties, which are properties where you have some type of federal assistance or a federally backed mortgage, a Freddie Mac or a Fannie Mae mortgage. It probably will not include all properties like the congressional bill. So if I had a crystal ball, that's what I would guess. On the state level, the state moratorium goes through the end of August. If I had a guess on that, the governor will probably extend that moratorium for an additional 60 days. That won't happen until the end of August. The governor will probably wait till the last minute to do it. He has till October the 31st to do it. He'll probably do it for another 2 months to keep it constitutional. That would take us to the end of October, which would be about 5 or 6 days before the election. Does anyone on this call think that the governor is not going to extend the moratorium 6 days before the election? So my guess is that that would get extended again till the end of December. At the end of December, we're looking at the winter time. Are they going to be looking for an additional extension? Who knows? So this is all guesswork. Nobody really knows exactly what's going to happen. We certainly don't know what's going to happen with the virus, which is going to dictate a lot of this stuff. You know, if we have another wave, it gets worse in the fall time, whatever, this moratorium is going to continue. City Council comes back in September. Are they going to extend the moratorium as well? Most likely. So if you ask me what I think is going to happen, I would say that most likely you're not doing evictions until sometime next year. This moratorium is going to continue into 2021. Even if you were able to file in September, which is the date when the current moratoriums are ending, my guess is the court's not going to give you a quick hearing date. They're already talking about dates toward the end of November. Even if you got into court then, once the courts are opened up, there's going to be so many filings that you're going to be lucky to get a date before December, January, February. And then you got to do a lockout on the back end of that. The courts are only hearing 5 cases every 45 minutes, which is half of the number of cases that they used to be hearing. So you can imagine with all the new cases, the backlog is just going to keep continuing. So it looks like the moratorium's here to stay for quite some time. So just want to get you guys prepared for that. As far as what the city is doing, the city bills, they passed the Emergency Housing Protection Act. Basically, it gives various protections to the tenants. The number one protection being that the evictions were stayed. The moratorium was till the end of August. Turns out didn't really matter because the governor extended the moratorium till the end of August anyway. We have filed on behalf of Hapco a lawsuit against the city of Philadelphia. I want to thank all of you. I see quite a few contributors on this call that have contributed toward the defense fund. We, at part of Hapco, we really appreciate your stepping up and contributing so that we could fight the fight. Tomorrow is actually the hearing starting at 10:30 in the morning. Will be the hearing on the preliminary injunction in federal court where we're suing the city to overturn the city ordinances. The biggest ordinance that we were trying to overturn, as I said, was the eviction moratorium, but that sort of became moot when the governor extended the eviction moratorium to the end of August anyway. The other bills real quick are the hardship repayment plan. Tenants have 9 months within which to pay back the money that's owed during the period from March the 1st through August the 31st. So any money that's owed by the tenant during that period of time from March 1st through August 31st, the tenants have the absolute right to reach a payment agreement where they pay that money back over a period of 9 months. They would still have to pay the ongoing rent. And if they miss 3 payments, then you'd be able to proceed with the eviction, assuming that the eviction moratorium is lifted, which I'm guessing is not going to happen anytime soon. So my suggestion to everyone is that if you can get your tenants to get money from the rental assistance program, I get it's only $750. $750 may be better than nothing. So you may want to consider that, knowing in the back of your mind that it's going to be a while before you're going to be able to do an eviction and actually get these people out. As far as the payment plans go, it's worth doing those as soon as possible. The sooner the better. So if you get someone on a payment plan and they start making those payments, that's going to be helpful. Before you're going to be able to do an eviction, you're going to have to send them a notice. Kenny is going to talk a little bit more about that and a program that we put together with Hapco and Kenny's office to be able to do the pre-filing and get that all started. There's also late payments. You can't charge late payments if they owe you any money between March the 1st and August the 31st, then you won't be able to charge any late charges through May of next year. There was a rent stabilization bill. Hapco, along with our real estate coalition, was able to defeat that bill. I always love that term, rent stabilization. Rent control is really what it is. So it was a temporary rent control bill. The problem was that, you know, everything's temporary till it's not. So city council gets a temporary bill through, then the next thing you know, that temporary bill, which we thought was going to end at a certain period of time, gets extended forever. And that's what the housing advocates are looking to do. That's pretty much everything I have. I guess Kenny's going to talk to you about the pre-eviction program that he's put together. And then we'll answer questions after that. That makes sense, Brian? Okay. It's all you, Ken. Mute him.
Ken,
How about now?
are you on?
I'm here, but I don't know if I'm unmuted yet.
You're good,
Am
Ken.
I?
Go ahead. You're good.
Okay, so I had, before I even begin, a couple of questions, and one is, the first one would be for Jared, and again, I appreciate all the work that you've done in light of your position, but the first question has to do with, do you have any sense of, is the governor going to, have you heard anything, is he going to extend that executive order, which expires August 31? I mean, that's 2 weeks from now. We have hearings scheduled beginning September 1 in some cases. So the question is do you believe that that's going to be extended? Because quite frankly, if the governor does extend, then the court is going to issue an order that's going to prevent us from going to court the week of September 1st. So perhaps if Jared could respond to that, just so we get a sense of where we may be. Is that possible, or for him to respond?
Hey, Ken. Thanks for the question. I would put it at about 80, 85% yes.
Okay.
Yeah.
I don't think we need any more than that. That answers the question pretty much.
I'm a little
And thank you.
higher than 80 to 85.
But Paul, and Paul knows, assuming that occurs, I had a meeting with the president judges of Common Pleas Court and Municipal Court not too long ago, a few weeks ago. And it's fairly obvious to me that assuming once the governor does extend that, the court is going to issue an order that's going to prevent us or prevent these hearings from taking place beginning the week of September 1. And again, you have to understand that these are cases, the cases that are currently scheduled to be heard beginning in September are those cases that were scheduled to be heard between March 13 and, for argument's sake, April 30. These are cases where tenants failed to pay rent in, for instance, for argument's sake, November, December, January, February, before the coronavirus was ever invented. Nonetheless, those are the cases that we're talking about because they are being scheduled to be heard before any new filings are being heard or being scheduled. So those were supposed to be heard in July. Beginning in July, that got postponed now till September and October, and it seems as though those are going to be extended again. So when we try to get a handle on when it is we may get into court regarding new filings, it's, as Paul said, we'll be lucky if we're in court in November at the earliest, but who knows? I mean, stranger things have occurred. The other thing, as far as the court extending that, what we've been doing and we will continue to do, and maybe before I get into that, Paul, maybe Paul can respond to this. Paul, we've talked about another procedure that we are considering following and filing on behalf of clients. Do you want me to get into that process or that procedure that you and I have discussed?
Why don't you talk to them about the pre-filing, and then I'll talk to them about the post-filing.
Okay, so what we're doing right now is that where you have tenants who are behind in rent, what we would ask you to do, suggest that you do, is you send over to Hapco the file, the information, lease, license, a certificate of rental suitability, a ledger, any notices that may have been sent, what you normally send for the eviction process. Once Hapco gets that information and puts all of that together, they send that over to us, and we prepare a specific and send a specific notice to tenants, and that notice includes information and language regarding any COVID-related hardship the tenant may be suffering. The tenant is given an opportunity to respond. We're keeping very, very careful records on this. These notices are going certified mail as well as regular first-class mail. But assuming the tenant responds that they're experiencing hardship as related to COVID, although I'm not sure what the proofs would be, but let's just assume we get that information back, then what we will try to do is to resolve the unpaid rent issue with, as Paul mentioned in his remarks, with a repayment agreement, which is going to take place out of court. Keep in mind and understand that under these circumstances, the tenant may be entitled to as long as a 9-month repayment plan, which I think we can all assume most tenants will opt for that 9 months in order to work out that agreement. Assuming the payment agreement or repayment agreement is met, and of course that also entails the payment of ongoing rent, but assuming that payment schedule is met, then in most instances we're going to be happy, we're getting our money, and everybody can go their separate ways. If the tenant breaks that agreement, then the court has devised, or at least talked about, or the council ordinance have talked about, a diversion program, which as far as I know, Paul, if you have updated information, that hasn't been set up yet. But this diversion program is to be set up by the court, where there will be, in essence, some sort of a mediation, where once again an agreement will attempt to reach an agreement. If that doesn't happen, then at that point we'll end up filing it with the court once the court permits us to proceed. If there is no agreement, or the tenant never claims a COVID-related hardship, then we can file, as we normally would, in municipal court again once the court reopens. The one exception to all of this is that, and what I just mentioned is applicable to those cases that are based solely upon non-payment of rent, someone who is failing to pay rent. If you have a situation where a tenant is causing damage to the property, threatening you, or any harm to you as the landlord, other than non-payment of rent, then we may be able to get into court sooner. But once again, all of that is subject to when the court is going to begin hearing these cases. And so all of that depends upon executive orders from the governor, and then orders from the president judges of common pleas and municipal court. All of that, those orders will determine when we may be able to get back into court. I mean, everything is obviously upside down for all of us. It seems as though there's been very little concern about the plight of landlords and mortgages and other bills that have to be paid. But, this is life in the big city at this point, and that I believe this is where we are. And hopefully, the courts will be up and running sooner rather than later. But I'm not sure that we can count on that occurring. We've given a lot of thought, and that's my office and Paul in particular, into another method, another way of trying to protect our clients. And I think Paul wants to get into that as opposed to me, if I don't want to step on anyone's toes. That sound about right, Paul?
Yeah, it's all good. So for what Kenny was talking about, the pre-eviction filing and what you should probably be doing, before you're going to be able to file in landlord-tenant court, when it finally opens up, you're going to have to send a hardship repayment notice. You're going to have to wait 30 days, and after the 30 days are up, you're going to be able to go into court. Additionally, as Kenny mentioned, once they set up this diversion program, in answer to your question, Ken, is they're talking about September 8th as the date. They're going to get it together, but I just don't see that happening.
Right.
Paul,
if I could just interrupt for 1 second. What's important about what Paul is saying, and in reference to the specific notice that we would be preparing and file and sending to the tenants, if you don't do it now, the benefit, I believe, of doing it now, and maybe Paul, you were about to say this, the benefit of doing it now is you're not going to have to do it on the back end. So if nothing else, we're at least 30 days ahead of the curve, as opposed to 30 days behind the curve if we wait until courts reopen. So if we're a little bit more proactive about these notices and actually processing these cases, you're going to be in court and be in a position to proceed whenever that may be, sooner rather than later. I kind of tell folks, listen, we're trying to maybe get a little bit ahead of the curve instead of being completely behind the curve. I'm sorry, Paul.
Yeah, no. So Kenny's exactly right. And if you don't do this now, what's going to happen is once the courts open up, well, let me go back. If you do it now, when the courts open up, you're going to be able to file right away. So you'll be the first ones to file. People are going to be filing like crazy. If you wait and have to send a notice out once the courts open up, then you're not filing for at least 30 days later. You're going to be so far behind the curve that by the time you get into court, who knows when that's going to be. So the concept is that if you have a tenant where they're just not paying, they refuse to pay, they're going to ride this out as long as they can, then you want to get that over to Kenny's office as soon as possible so that they can get started on this and get those notices out so that when the courts open up, you're way ahead of the curve. The other thing that we've thought of in doing is right now to be able to sue the tenants for the rent that's owed. Not ask for possession, but sue them basically as a small claims case for the money that's owed, and there's a lot of advantages to it. I don't have a lot of time tonight to go through all that. What we're going to be doing is setting up a seminar where we go through all of these things and explain in much more detail exactly what you should be doing, how it works, what's the advantage and disadvantage of each thing that you can do. So do you file for the notice first? Do you file the lawsuit first? Do you wait? There's a lot of different variations of that. So my suggestion to you is check the Hapco website. It's these guys have done an awesome job in putting together that website. Very informative. There's a lot of information there. Very helpful. You should be checking that weekly, if not daily, to see what's going on, because the laws just are constantly changing. We'll have all that information up there for you, and stay tuned for the day for a seminar where we'll go through in detail exactly how the different laws work, where we're at with them. We'll tell you where we're at as of that day, because every day it changes. And then we'll tell you what's the best approach that you should be taking to protect yourself going forward.
There, one other point which Paul mentioned, and just so that you understand what's happening, municipal court operates 2 sessions on the landlord-tenant side, basically 8:45 in the morning and then 12:45 in the afternoon. Over time, that 8:45 list usually has anywhere from 80 to 90 cases a morning, sometimes even more, but let's say 80 to 90. The afternoon list has a little bit less, maybe around 50 to 60. So if the court was hearing 150 cases a day, every day, 5 days a week, between the morning and the afternoon sessions, what they're now doing and the way they're scheduling cases, every 45 minutes, they're putting 6 cases in the courtroom. Therefore, in the morning, the court is hearing approximately and scheduling approximately 30 cases. Same thing in the afternoon, 30 cases. So instead of 150 cases a day, we're going to be lucky if they hear 60 cases a day. So that's initially with respect to the incredible, terrible backlog dating back to mid-March. And then just figure, try to figure out what it's going to be like moving forward. So the longer you wait in processing these cases and turning these cases in, you can picture the disaster that we're all facing. This is not our doing. It's not your doing. This is just the way it is. But again, when you look at the possibility of the court disposing of maybe 60 cases a day, as opposed to 150 cases a day, you can clearly see just where the delay is not going to get any better. It's going to be considerably worse. So just something to be thinking about.
That's one of the reasons why we want to try to get the mediation through Jared Solomon. The other thing, I just want to put a plug for Hapco. I want to let you know that it's been a lot of hard work and membership of Hapco. We need to get more and more people to help support Hapco. This is the only organization that really supports low and moderate income landlords. Tell your friends, very reasonable. Also, if you have to file these cases, talk to Denise, talk to Kenny, talk to Paul, but the website, I would suggest you try to file the cases like Kenny and Paul said. So please tell your friends to join Hapco. We really hit an expensive time now with, I hate to say this, less and less members. So please put the word out. Paul?
If you guys don't mind, we're going to ask Greg to step in and say a few words before we jump forward.
Thank you. Hello, everyone. So we've been going through a rebranding process. 6 members from Hapco have stepped up to rebrand Hapco. One part of the rebranding has been our name. We now have a new name, Hapco Philadelphia. Along with the new name, we have a new logo. We have an incredible website, and we're even looking at the newsletter, and we're changing that and going to go electronic with that. If you haven't been to our website, it is the most comprehensive, up-to-date website in the country. And how do I know that? Because I take it upon myself to go visit other websites, other landlord websites, and ours is one of the best, if not the best. Everything's up to date. Everything that the lawyers have discussed today is on there. That's the go-to place. And yes, you should visit it every day because it changes that quickly. With today's COVID nonsense that's going on, it changes so quickly. Everybody wants to know what's happening. That's the place to get it. It's up to date, it's comprehensive, and we at Hapco are very proud of it. We need members, just as Harvey just said. One of your biggest projects is for you to go out and recruit. How many times you run into somebody that's a landlord and never heard of Hapco? Happens all the time to me. You've got to point them in the right direction. A lot of people don't know where to turn for help. This is the only organization that's available to help landlords in this city. Without this organization, who knows where we'd be at right now. I probably wouldn't be in the business, that's for sure. One of the things that I also want to point out is that our newsletter is about to go digital, and we think that this is the wave of the future. This is the way to go. Everything electronic now, and I know there's going to be a couple of people out there. They're going to say, "Well, I like to have the paper in my hand." If that's the case, you can call Denise, and we'll make arrangements for that. But we're really looking to cut costs and be up to date. Also, our social media sites, YouTube, Facebook, they're up to date. They're running. I know in the past there's been complaints that, hey, no one's even done anything to these websites for months and months and months. That's all changed. Everything's up to date. As well as one final note, we're going to be sending out a survey at the end of September. And let me tell you, this is not the only survey. There's going to be more. These surveys are so important. These surveys are going to help us at Hapco direct where we need to go. Please take time out, fill it out. Take some time out. Let us know your thoughts. This is really important. I want to thank all our members who step up when we need them, because right now, during this time, we need each other more than ever. Thank you.
Thanks, Greg. Well said. Get back. I think I was talking Paul Kevin.
I think we were going to, at this point, answer questions, Brian.
Yeah. Give me 1 second. Paul, if you want to start with some of the obvious, which is what one person asked about the idea of what it would cost to cover the cost of the suing. For obvious reasons, you can respond and explain where we're not at that point yet.
So we're putting the programs together. As I mentioned before, we're going to have a seminar on it where we're going to explain all the different options that you have, and we'll go through all the pricing at that point, and let you know. And again, check the website. It'll all be on the website, all that information. It's all this stuff changes every day, but it's a new program. We got tired of just like not being able to do anything. This is crazy. So we're just sitting here waiting for September. First, we were waiting for July the 10th to come by so that we could start filing. Then that got changed to August the 31st. And then we're sitting here thinking, okay, well, we're waiting until September 1st. We all know that's not going to happen either. So we got to do something. So that's why I got together with alternatives for you guys to be able to do something so that people just can't continue to thumb their noses at you and just not pay the rent. And mind you, if they, obviously, and trying to get this across to the press all the time, is that when you have a tenant that's a good tenant or it's running into problem, you guys work with them all the time. That's not a problem. It's not what we're talking about here. We're talking about the tenant that has the money and just refuses to pay and just taking advantage of the situation, and that's just got to stop. And that's what we're doing here, and that's what this program is going to be all about.
And hasn't paid for 7 or 8 months.
Yeah, right. It's not longer.
Yeah, in some instances longer.
Okay, I see what the question. If we're in the process of evicting, are we still able to show the home to prospective tenants? The answer is yes, but again, it's a practical question because is that tenant going to let you in? The tenant that's currently in the property is going to say it's a COVID-19 thing. They don't want anybody in their property and yada, 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 and they're going to keep you out. So what are you going to do? You can't call the police to come. The police aren't going to do anything. So do you legally have a right to do that? Absolutely. As a practical matter, are you going to be able to if the tenant refuses? No.
Plus, they're probably going to badmouth you to the new prospective tenant or purchaser, as the case may be. It's probably lose-lose down the road, all the way down the line. So just something to think about.
Make a point.
Another question was, I think we answered it earlier. When will the filing be possible if your eviction is not based on non-payment, but based on a lease breach? But I believe you said earlier, the timeline of how everything is going to flow.
Yes.
Yeah, it's all going to depend on when they're going to let us begin filing again and holding hearings. So although there may not be a moratorium per se, in that instance, there is one because we can't get into court. So like Paul said, everything is up in the air. We all have our feet planted firmly in midair. And when we hear back that we can do A, B, or C, we're going to let everybody know and we're going to do it.
If the city, Jim asked the question, if the city is extending the eviction moratorium, will they also be extending the COVID hardship period? I don't quite understand that question, but
yeah, I get. So right now, the COVID-19 emergency period runs through the end of August, and everything's really tied to that COVID-19 emergency period. So there's the emergency period, and then there's the retroactive emergency period, which basically means that everything goes from March the 1st to August the 31st right now. So what the city would do is they would just change the definition of the COVID-19 emergency period to whatever date they want. And by just changing that definition would effectively change when the moratorium would end. Does that make sense?
Yep. The membership is $125 a year. The website address I'll put in the chat, everyone. Some of these questions I'm not going to ask the attorneys.
Yeah, just $125 is extremely inexpensive for what you're getting for this organization. It's amazing. I've never, I belong to tons of organizations, and $125 to get everything that you get from Hapco is just incredible. I was a member of Hapco many years ago, just because of how inexpensive it was. Like, it's $125 for all the benefit that you get. It's just, it's just incredible. So just need to throw that.
One question that was submitted.
Let me add this, that we were trying to keep it. That was one of the things that we're trying to keep costs down, but our expenses keep going up. And please, to help us keep costs down, try to talk to your friends, anybody. People call all the time. They have one question. They own one property. It's worth it to find out and to join Hapco. The more people that join, the way easier it is to keep costs down. And you see, we have great representation. We have political knowledge of who to talk to, and we're lucky to have somebody like Jared Solomon, who's state level. We have city level, and so please talk to your friends. Try to get more people to join. Brian.
If you learn one thing from Hapco, it'll save you 10 times that amount of money. And just with that, what Hapco's done with the lawsuit and fighting for you guys, it's just incredible. For $125, it's a no-brainer.
I got a couple more questions that came in. Sean, I didn't forget your question. You submitted it earlier, but I'm glad you asked it again. I was getting to it. What if the original tenant moved and it wasn't for non-payment? It was just for possession, but another person just squatted in the apartment. Paul, I think it's straightforward, right?
Good luck.
Yeah.
Well, when you say another person just squatted, how did that person get into the property, if you know?
I think when they submitted the question, I think the original tenant let those individuals in. But Sean, you can respond in the chat and I'll clear it up.
Well, just let me say this in response to that. If that is the case, then the position that we've always taken, if, let's say, Paul Cohen leases the property to me, to Ken Barrett's, and now I walk away, but before I walk away, I say to Brian, listen, I got a place. Why don't you come on in? It's all set up and good for you to go. I have not, me, the tenant, Ken Barrett's, I have not turned over possession because I haven't turned over possession to a vacant unit. So we would file that action against Ken Barrett's and all occupants. And the court is generally going to entertain that case and handle it as in the normal course of events. Now, if there's been interaction between the landlord and Brian, that may change things around a little bit and may be a different set of facts that might legally impact my response. But if the scenario is just as I stated, I never turned over keys. I just gave the keys to Brian and he's now hanging out. There is a method that's, that we can proceed with a landlord-tenant case, not have to necessarily file this as a ejectment action in the Court of Common Pleas, which is much more expensive and potentially much more time-consuming. It still can go into municipal court as a landlord-tenant eviction. So that's something we do all the time under those circumstances.
So something we used to do all the time.
Yeah. Well, it used to be a lot easier way back when, but we still can get those cases through if the fact pattern and the facts are exactly as you just said. I never vacated. I never turned over the keys. I just walked away and left some guy there.
Next question. This one sounds like it's a little tricky, but Sonia asks, I have a few tenants who moved out and their relief checks and unemployment checks have arrived. Can I hold them as property prior to going to court?
Probably not a good idea to touch anyone else's mail, among other issues that might be involved with that. But number one, if there's mail addressed to this tenant, I'm not sure I would be in the middle of holding on to that or anything else or disposing of that. That's creates a lot of different problems that a landlord doesn't need to be in the middle of.
It's a federal offense.
That too. Well,
to mess with somebody.
That's one of the problems. Yes.
So you don't want to get near that issue. Yes, it's a huge problem. Just as an aside, real quick, the Postal Service is probably one of the toughest law enforcement organizations in this country. They take their mail very seriously, and you mess with that, they come after you. So whereas the police department, because I had this situation personally, whereas the police department, they generally don't care, especially in the city of Philadelphia, about these minor offenses. The Postal Authority, they take it very seriously. So do not mess with somebody's mail.
That's a big mistake.
Yes.
I'm just going to keep jumping in between. I want to get these questions, guys, just so you know. If my tenants have month-to-month leases, are they affected by the moratorium? I'm pretty sure the answer is, well, Paul, you can go ahead.
Yes, that's an easy one.
Yes,
they are affected.
And then can a landlord/tenant judge not honor or rule against the landlord if the landlord gave proper 30-day lease termination notice to the tenant?
Judge can do anything he or she wishes to do, wants to do in a given situation. So don't assume, never assume that if you're right on the law and even right on the facts, that a judge is going to find in your favor. That's not exactly how it works. There are a lot of judges who do a lot of things that Paul and I have difficulty sleeping at night over some of the things they do. So don't assume they're following the law. Some do, some don't. So, you know, there are no guarantees. That's the best answer.
As one judge told me when I was a young attorney, when the judge just made a terrible decision, and I said, "Your Honor, how could you decide that way? It goes against the law." And I rattled off what the law was and explained how, based on this set of facts, there was no way the judge could decide that way. I said, "Your Honor, how can you decide that way?" And she looked at me and she said, "Mr. Cohen, I just did." So the answer to your question is the law is what the judge says the law is.
The next question is the language for the moratorium explained that it is for those who are not working or not working and not for those who are able to pay.
Well, the language, I believe, is rather general in nature. It talks about a COVID-related hardship. I have no idea what that is. I don't know what that means. So that I think you can anticipate that tenants are going to claim a COVID-19 hardship. Not that they know what it means either, but sadly, many judges are going to be satisfied with what where a tenant says, "I was affected in some fashion as a result of the coronavirus."
Yeah, and it gets even worse than that because there's actually a presumption of a COVID-19 financial harm. So once the tenant alleges it, you're going to have a really, really hard uphill battle proving that they don't have a COVID-19 financial harm. Quite frankly, from a legal standpoint, I wouldn't even waste the time trying to argue it. Tenant's going to say that they have that harm, let it go, and just try to reach the 9-month hardship payment arrangement with them. If they refuse to reach that payment arrangement, then you would be able to still proceed with the eviction.
I think this one is a straightforward. I won the case, but I was supposed to file the writ, but now the court is closed. I think you.
So everything is on hold as a result of the moratorium. So for argument's sake, we all have cases that went to court, for instance, late February, early March. The court shut down, I believe, March 13. So even if you had already filed a writ and that writ was accepted by the court and served prior to March 13, once the court shut down, everything stopped. So the only thing that, as I understand it, that we may not have to do is we may not need, judgments for possession are good for 180 days. It's my understanding that we will not need to file petitions to extend the 180-day rule under these circumstances. However, we have to wait until the court will again begin approving writs of possession and or alias writs of possession, and then the scheduling of those lockouts whenever that may be. Right now, we're shut down. We're all shut down. Every aspect of this process is shut down. So, we've got clients or people out there who got a judgment for possession, for argument's sake, the end of February, and they were getting ready Monday, the 13th of March. They were ready. They called us and said, "Hey, Ken, go ahead, file the writ of possession." That's when the court shut down. Couldn't file it, can't file it, not being served, can't move forward. So it's horrendous. It's a disgrace. these are people who are sitting there and laughing at us, and there's nothing we can do. So we're all affected. We are, in fact, affected by this moratorium until it's lifted. We were hoping it was a couple of weeks away, but my sense and everyone else's sense is that we're not just a couple weeks away, we're at least a couple months away.
Yeah, and in addition to the state of emergency and the healthcare state of emergency, we're also in a judicial state of emergency. So the Supreme Court has declared that there was a judicial emergency, which allows the different president judges in different courts to issue executive orders. And as Ken is saying, like one of those orders specifically says that you can't do writs of possession or alias writs of possession until the beginning of September. But good luck with that not getting extended. As I said in the beginning, all those dates most likely are going to be extended to God knows when.
Now, I referenced earlier, I had a meeting, maybe it was a month ago, maybe less, but with the president judges of municipal and common police court. And one of the things I specifically mentioned to them were those cases that either we'd already taken to court and have judgments on, but again, even more specifically, those cases where this was non-payment of rent for December, January, February. And I said, you know, you guys got to do something about this. And their answer was, you know, Ken, we understand, we know, we agree, but we're not doing anything. So that's where we are.
Paul mentioned earlier that we're going to try to schedule another meeting at some point in time to explain the process of how to file everything with all the new laws. There's a couple questions that are surrounding that. So at some point, Denise will send out that information on when that meeting will be. My question to Ken, I would say, is if, for sake of the conversation, this is August 18th, if we set that meeting for the middle of September, does it matter considering that any new cases that need to be filed and how to be filed won't be able to get done in September anyway?
Well, let me answer it this way, and I think Paul will weigh in on this as well. I think that we, Paul and myself, would hopefully this seminar as such could be sooner than a month from now. That's number one. And number two, we're really putting together the final touches and procedures to be followed that may help everyone, you know, move forward in some regard to relative to this non-payment of rent issue. So we're not sitting on our, you know, behinds and not doing anything. We're working rather diligently in terms of coming up with not only the procedure and the process, the dollars and cents, but we're keenly aware of the time frame. We'd like to get this moving forward sooner rather than later. We think it's a benefit to certainly to the Hapco membership to do that. So without putting any type of pressure on anyone, I'd like to think we're going to be moving forward on this and sooner than a month from now. You agree, Paul?
Yeah, I'm actually getting hungry with whoever's cooking there.
Yeah. Well, yes. Evidently, my dinner's almost ready. So.
Veal parm and spaghetti.
Yes, we're going to try and do it sooner rather than later. There'll be a nominal charge for it. And it's something that will definitely help everybody. It's something that will go through all the different laws, so you know exactly where you stand, and you'll see what all your options are. So you're not going to just sit back and do nothing. So just check the website, and we'll have it all posted up there when the next meeting is.
I mean, one of the things we decided very specifically was, you know what, we've not that we've sat back, but enough is enough, and it's at some point we need to do something. We've come up with something that we think is will be effective and will be helpful because we got to do something. So
yes. There's a couple more questions. Everyone, we will try our best to answer as many questions as possible, but just keep in mind the time that it is now. It's 7:25. I think this is an owner-occupied question, but it says, I am a living landlord and want the tenant who lives above me to leave because of their issues not related to non-payment. Will I have a special circumstance for eviction? And I think the answer is no, right?
If there's,
Depends what the issues are. If there's a threat to the health and safety and welfare of the landlord, or in this instance, I believe damage is part of that. Damage being caused or any type of a real nuisance that you can prove, then there may be an avenue, once again, once the court lets us hold hearings.
Yeah. But
Paul,
right
I don't
now,
know if you have.
right now with the courts not being open, it's not much anybody can do, right?
Nope,
you can still,
no hearings right now.
you can file if it's
We're all shut down.
if it's an imminent, you can get a hearing date on it in theory. We took one case into common pleas court where the situation was really bad. Person had set a fire and it was like a really bad situation. I'm not gonna go through all the details with you. But the bottom line was I waited for the right case because I'm a big believer in choose your battles. And if you're going to battle one of these cases, you want to make sure that you're going to win it, especially the first one that we take. So I took the case that I thought was the perfect case, took it into common pleas court, and I got a one-word decision. It said, denied.
Who was that from? Which one?
I forget which judge did that in common pleas court.
Neither one of them are particularly terrific, but that's another story.
Bottom line is that right now in this climate, it's going to have to be really bad and you're going to have to get really lucky in getting a judge to evict a tenant right now.
Yep.
This meeting was supposed to end by 7:30. So if there's anything imminent, I guess we can get in touch with Denise. Anything else, Brian, that's imminent on this?
There was a couple minor, couple last minute questions to Jared Solomon, if he's still
still
here.
here.
Give me 1 second. The one question was, sorry, just getting to it.
Hey, Brian, my veal's getting overcooked. Come on, man.
I apologize.
So
There was a question about the idea that most landlords are filing their income from their properties for Schedule E income on their taxes. With whatever happens with the state, with what you're working on behind the scenes, is that going to be taken into consideration? I'm sorry, Moody.
Can you, Brian, can you, what is the situation that a landlord's facing, and which piece of legislation?
So here's the question. Most landlords who report their income using Schedule E do not qualify for any grants. Is it possible to provide legislative language that will cover this type of landlord?
You mean for the rental assistance as part of a mediation program?
So
I think
go ahead, Paul.
where they're going with this is the PPP program. So
Oh.
under Schedule E, you didn't qualify for the payroll protection program loan. You had to file under Schedule C. And a lot of landlords, when they file their tax returns, in order to save on the Social Security tax, Medicare tax, they do it as an investment income. And if you do that, which is basically Schedule E on your tax return, then you don't qualify for the PPP loan. So that would actually have to be done on a federal level. That's not something that Representative Solomon would be able to do. I think that's the
Thank you, Paul.
question.
Brian, anything else?
Yeah, I think that's it. The one good thing is we had a lot of questions. I appreciate everybody sending the questions in. One person, I'll say this last comment. that, you know, we're getting so much negative news. The good thing is we're all coming together as this group, regardless of the number of people. We're trying to create positive solutions. Jared Solomon, he's kind of a middleman in between trying to work the tenants and the landlords. So we all need to try to take into consideration that, you know, we're keeping our eyes open. We're trying to be patient. Just got to keep holding in, and hopefully we can get some things done to make the situation less harmful as it currently is, and we'll see what happens.
That's well said, Brian. And we appreciate everybody that tuned in here. And again, and for Representative Solomon and our attorneys for tuning in. Any other things that we can do, go to the website, call Hapco, Denise. And again, try to help us with the membership. That's our ways of keeping Hapco alive. Anybody else have anything? If not, thank everybody for coming.
Thank you, Harvey. Thanks all.
Thanks so much.
Thanks.
Thank you, everyone. Have a good evening.